The proposal to build a bridge linking the South Australian mainland to Hindmarsh Island led to several significant court judgments. This one, for introductory students, looks at the clash between Australian general law and Indigenous tradition. Traditional inhabitants sought to stop the bridge under the Commonwealth's Aboriginal and Torres Strait Islander Heritage Protection Act 1984. They claimed that there were a range of traditional beliefs linked to the landscape which could only be known by women. Under that act, the minister, Robert Tickner, a man, was required to make the decision. So he appointed Professor Cheryl Saunders, a woman, to prepare a report in accordance with the Act for his decision. She did so, but the minister was not shown and therefore did not consider all of the submissions made to Professor Saunders. Such consideration was required by the legislation. He had a female staff member review them and report to him. Minister Tickner was clearly trying to make a fair decision while respecting Indigenous tradition. It didn't hold up in court. There were several procedural problems, but in the full federal court, Justice Burchett said annexures were deliberately withheld from the minister because they recorded details of the claimed significance of areas including Hindmarsh Island, which, it was said, the relevant Aboriginal tradition required to be hidden from men. The minister is a man. There is no doubt about the public interest in the preservation of confidentiality, where Aboriginal tradition holds sacred information about a particular area, in a sense that would exclude certain persons from the site or from possession of the information. But Aboriginals, just like all their fellow members of the community, if they wish to avail themselves of legal remedies, must do so on the law's terms. To take away the rights of other persons on the basis of a claim that could not be revealed to the maker of the decision himself would be to set those rights at naught, in a way not even the Inquisition ever attempted. So the law held that respecting Indigenous culture was important, but if Indigenous people wanted the law's protection, then the requirements of the law would prevail over traditional culture. This left Aboriginal people between a rock and a hard place, where the only way to protect their culture was to abrogate it. The relationship between the law and Australia's First Peoples remains fraught and complex.